It's that time to slide towards Qanun. This will be headed by that famous attorney at law, Mr. Raja Bhandari from Raja Bhandari Law Offices and Sex and Settlements located in Annandale, Virginia. This week, Attorney Bhandari will answer, does joint tenancy avoid probate? Let's see.
Good afternoon. This is Raja Bhandari from Sex and Settlements and Raja Bhandari Law Offices of Annandale, Virginia. Welcome back to Qanun. Friends, now we're going to start few of your questions. Last time I was talking about the probate. Probate is not a small issue. We will be talking few questions on that particular subject. Again, in forthcoming weeks, I will be talking about will and living trust or revocable trust or power of attorneys and all other related document in the estate planning. We will be touching each subject on that particular issue, but at the same time I would request again to all of you, any question you have related to this particular area, so send it to us, to our studios, so we will definitely entertain those questions. You can call or you can email to our studios. Let's start that. The question I have, does joint tenancy avoid probate? Now, what is joint tenancy? Let's say that when you have a ownership with two owners, it can be husband and wife, it can be brother and sister, it can be two friends, any way you want, because in the property system you can own property four ways: as a sole owner, as a joint owner, joint tenancy, tenancy in common, and tenants by the entirety. So these are subject totally different from whatever we are talking about. We are talking about now the joint tenancy. Joint tenancy, of course, joint tenancy, if one person dies, the property, if you have a joint tenancy with the right of survivorship, the property transfer to the other person. Of course, for the time being, that do not go in the probate. So that way you have the right to own the property without going to court or without forming a estate. However, if let's say that if you are a husband and wife or a brother and sister or a friends, you own the property, you own the property as well as personal as well as real estate as a joint tenants with the right of survivorship, it can hold until one person is alive out of those two or three or whatever the case may be. However, if the person who is survived the other person who dies earlier and then own the property now 100%, either it's a tangible or the real estate, whatever the way it be, then if that person dies, obviously the whole 9 yard has to take place, means has to go to probate. But at the same time, it is a dangerous situation. Let's say that, for example, when you have a joint tenancy and there is a judgment against one of the person, that will attach to the property in exception of tenants by the entirety, which is husband and wife property with the right of survivorship. With the exceptions, it is a IRS or is a state lien or the student loan and or maybe the alimony. So it's a complication situation, but at the same time, joint tenancy, when we are talking about joint tenancy, so if it's a regular joint tenancy between two friends or brother and sisters other than husband and wife, then if the judgment takes place against one person, that particular person's interest in the property can be held by that judgment. Obviously, until otherwise you satisfy the judgment or you pay that off or you negotiate it and it's released completely from the record, that property is encumbered by the judgment. Now, the other questions I have, that what problems are there with the joint tenancy? Again, I just explained it to you. These are the kind of the problems we have. One is that it also has greater tax implications. When you have, obviously, we will be discussing this with one of the segment with money. He's going to be doing the taxes as well as the insurance segment on our program. So he will be discussing about the taxes. I cannot go in there, but there is a greater tax implications on that person if the one person dies and the other person owns the property 100% now. Now, you may end up controlling the property with a stranger or with the other person. However, you have to make sure that you have a properly legally written document. If the one person dies, and then obviously now you become a owner by chance, because not by chance, by default, because you are a joint tenants with the right of survivorship. However, if you die now, that particular property will go in the estate and go in the probate. That's what we talk about. And all that complications, all that expenses, all the public record situation, all the taxes that has to be paid by your heirs, of course, and your estate before, and then they will be distributed accordingly the way we discussed earlier. That is because now you are 100% owner. So friends, we will be talking about next week that if one person is get incapacitated, that person is not able to make a decision either because of illness or any other reason for that matter, how that person should be treated and how we can handle that situation. In those kind of circumstances, there are legal tools that you should have that can save lots of money. I will give you examples that is a public record, but at the same time I will explain it to you that how it can be possible or how it can be achieved, paying very little money in advance and then saving a lot of hassle and money. Friends, time is up for today. This is Raja Bhandari taking a leap. So long.